theory of law that says that every law is backed with sanction, which means the person who goes against the law will be punished. So in a contract of sale of goods, where there is a breach of contract, depending on who occasioned such a breach, there is an action, there is remedy. Who can bring action to seek what remedy? Let us look at the provision of the law. Now, depending on who occasioned the breach, whether it is the buyer or the seller. Now, if it is the seller who occasioned the breach, it means that the buyer can also bring action for breach of the contract. If it is the buyer that caused the breach of the contract, it means that the seller can also bring an action for such a breach. So let us look at the provisions that the law has made for actions for the breach of a contract of sale. Let us look at the remedies that are available to a seller under a contract of sale. Now there is action for price. That is number one remedy. Action, which means that when a seller has agreed with a buyer to sell and the buyer has agreed to buy, the buyer is expected to pay the price for those goods. So where there is breach on the part of the buyer to pay for those goods that has been received, the seller has the right, a remedy to bring an action for the price of those goods, especially where such a buyer has refused to make payment, or they have both agreed that this is the so and so time that is fixed within which this buyer should make payment, and that time has passed. The seller can bring action for the price of those goods. Number two is that he can also bring sue for damages for non-acceptance. The law says that the buyer has two duties under the law: pay the price, accept goods. So if non-acceptance has occasioned loss, inconvenience to the seller can bring an action for damages for non-acceptance of those goods. Okay? Has also provided remedies for the buyer. Okay? Has also provided remedy for buyer. So if the seller fails to deliver, because that is the duty that the seller owes the buyer under the law. If the seller fails to deliver, it means that the buyer can also bring an action for what? Non-delivery. The buyer can also bring an action for specific performance. Okay? Now, there are also remedies where the breach relates to warranty under the contract of sale of good. Where it relates to a warranty, the buyer can do what? Bring an action against such a seller. Because warranty, I have explained what a warranty is in one of my previous videos, which is a written statement by a manufacturer or a seller that he's going to make something good, a product good, should anything happen to it. And it does not matter whether such a seller is just a seller and not the actual manufacturer of that product. This is Xavier Law Essence, where we give you premium legal tips to help you make informed decisions, live informed life, and discover the best version of yourself.